The most expensive mistake an HOA can make isn't breaking something. It's assuming the owner has no way to answer back. The first thing I noticed that Tuesday morning wasn't the sound. It was the smell. Fresh diesel drifted across the water before the sun had fully climbed over Pine Hollow Lake, mixing with the cool scent of damp cedar and algae that had surrounded my family's property for as long as I could remember. By the time I stepped onto my porch with a mug of black coffee warming my hands, the rumble of heavy equipment was already echoing across the shoreline. One of the HOA maintenance trucks had backed across the narrow private access bridge leading to the lakeside cottages, its oversized rear wheels grinding against steel guardrails that had been engineered to handle passenger vehicles, not overloaded construction equipment. Then came the sharp metallic crack. It echoed across the lake like someone snapping a giant tree limb in half. I watched one of the primary support beams twist just enough to make my stomach sink. The foreman climbed out, looked underneath for maybe 10 seconds, shrugged, and drove away as if nothing had happened. That bridge wasn't just another neighborhood crossing. My grandfather built the original version in 1974 after buying the shoreline from an aging cattle rancher who wanted the land preserved instead of developed. 20 years later, my father rebuilt it with reinforced steel after a historic flood. 5 years ago, I redesigned it myself. My name is Ethan Caldwell. I'm 38 years old, a licensed structural engineer, and every bolt in that bridge had passed through my own hands before it ever carried another family's SUV toward their million-dollar lake houses. I knew exactly what I had just seen. The damage wasn't cosmetic. It compromised the load distribution along the eastern support frame. If ignored, every vehicle crossing that bridge would accelerate the failure. By noon, I had photographs, drone footage, engineering measurements, and a repair estimate sitting neatly inside a report that totaled exactly $28,500. I wasn't angry. Not yet. Accidents happen. Responsible people simply pay for them. I emailed the report directly to the Lake Haven Shores HOA office and expected the matter to be resolved before the weekend. Instead, less than 3 hours later, an email notification flashed across my phone. I opened it while standing beside the cracked support beam, the afternoon breeze carrying the faint smell of hot metal and lake water. The entire response contained only 3 sentences. After reviewing your request, the association accepts no responsibility for the alleged damage. Your invoice is denied. Future correspondence should be directed through HOA legal counsel. I read it twice just to make sure I hadn't missed something. Alleged damage. The word almost made me laugh. There were tire marks across the steel. Security cameras had captured every second. The maintenance truck's own identification number was visible in crystal clear resolution. Yet somehow they believed the easiest solution was pretending reality didn't exist. Their confidence told me something far more valuable than the email itself. They believed they held every card. They believed the bridge, the road beyond it, and the only entrance to 32 luxury lake houses would always be there waiting for them, exactly as it had been every morning for the last 15 years. They believed access was permanent. They believed ownership belonged to convenience instead of paperwork. Standing there with the wind rippling across the lake and the damaged steel humming softly beneath my fingertips, I remembered something my grandfather used to say whenever someone confused permission with entitlement. People never notice the gate until the day it doesn't open. At the time, I thought he was talking about fences. The next morning, everyone in Lake Haven Shores learned he had been talking about something much bigger. Most people looked at the bridge and saw a convenient shortcut to their vacation homes. I looked at it and saw 3 generations of my family keeping a promise. My grandfather, Walter Caldwell, bought the shoreline in 1974 when Pine Hollow Lake was little more than a quiet fishing spot surrounded by oak trees and gravel roads. Developers wanted the land even back then, but he believed some places were worth protecting instead of squeezing for every dollar. He built the first narrow timber crossing with his own hands so neighbors on the opposite shore could reach their cabins without driving an extra 11 miles around the lake. There was never a toll booth. There was never a security gate. There was only a handshake and mutual respect. My father, Daniel Caldwell, inherited that philosophy. After a 100-year flood damaged the original crossing, he invested nearly everything he had rebuilding it with steel supports and reinforced concrete. He could have closed access permanently because the bridge stood entirely on our private property, but he believed good neighbors treated each other fairly. Every family using that road signed a simple access agreement acknowledging one important fact. They were receiving permission, not ownership. When my father passed away, the responsibility became mine. I expanded the structure, upgraded every support beam, installed drainage systems, and added remote monitoring sensors because that is what structural engineers do. We solve problems before other people notice them. I never imagined the greatest threat would come from the very homeowners who benefited from crossing it every single day. Lake Haven Shores grew rapidly over the past decade. What started as a handful of lake cottages became 32 luxury homes with stone fireplaces, oversized docks, and boats that cost more than most people's first houses. Property values climbed, attitudes changed, and somewhere along the way gratitude quietly disappeared. The new residents assumed the bridge had always belonged to the neighborhood because nobody had ever challenged them. The HOA certainly encouraged that belief. Their newsletters described the road as a shared community entrance. Their welcome packets included maps highlighting the bridge without ever mentioning my family's ownership. I noticed the wording years earlier, but chose not to make an issue of it because the recorded agreements filed with the county spoke much louder than marketing brochures. Then Victoria Hale became HOA president. She drove a white, luxury sport utility vehicle that always looked freshly detailed, wore expensive sunglasses even on cloudy mornings, and carried herself with the confidence of someone who believed every conversation ended the moment she finished speaking. During board meetings, she loved using phrases like community assets and neighborhood authority, even when discussing property the association did not own. More than once, she casually referred to my bridge as our bridge. I corrected her politely every single time. She smiled, nodded, and repeated the same mistake a month later. Looking back, I realized it was never an accident. It was rehearsal. The more often people heard those words, the easier it became to believe them. Standing beside the damaged support beam that afternoon, I brushed my hand across the cool steel and felt a faint vibration traveling through the frame whenever another vehicle crossed overhead. The bridge was still safe for light traffic, but only because it had been overbuilt from the beginning. My grandfather always said that strength gave you time to make the right decision instead of the fastest one. I decided then that I would follow his example. I would not raise my voice. I would not argue across meeting tables. I would let paperwork, engineering, and patience do exactly what they had always done in the Caldwell family. Victoria Hale understood one thing better than most people. If you repeated a lie often enough while wearing a confident smile, eventually someone else would repeat it for you. That was exactly how she ran Lake Haven Shores. Every monthly board meeting felt less like a neighborhood gathering and more like a carefully managed performance. The clubhouse always smelled faintly of fresh coffee and lemon furniture polish. Soft jazz drifted through hidden ceiling speakers, and neatly arranged folders waited at every seat before anyone arrived. Victoria loved appearances because appearances made authority seem unquestionable. She greeted every homeowner by first name, complimented landscaping, praised new paint colors, and then quietly reminded everyone that maintaining community standards required strong leadership. Most people nodded, without asking where those standards actually came from. I attended only when necessary. My property was adjacent to the subdivision, not governed by the association, but our shared access agreement occasionally required my signature on maintenance schedules involving utility crossings near the bridge. Every time I walked into that room, Victoria introduced me with the same carefully chosen phrase. Ethan helps maintain the entrance. I corrected her every single meeting. I own the entrance. She would smile politely, apologize, and continue speaking before anyone had time to think about the difference. Over time, I noticed something interesting. New residents started repeating her version instead of mine. They believed the bridge was simply another neighborhood feature, like the clubhouse or the marina. Nobody questioned it because nobody had ever needed to. Convenience has a strange way of rewriting history. Victoria encouraged that illusion whenever possible. She approved landscaping crews trimming shrubs along my private road without asking permission. She instructed maintenance trucks to stage equipment beside my retaining wall because it was, in her words, community property. Decorative banners announcing summer festivals suddenly appeared along the bridge railings every holiday weekend. Each time I removed them and quietly delivered them back to the clubhouse. Each time she acted surprised. I thought everyone enjoyed the decorations, she would say with that practiced smile. I always answered the same way. Enjoying something does not create ownership. The room usually became very quiet after that. A few longtime residents remembered my father and understood exactly why I insisted on precision. Others rolled their eyes as though legal boundaries were little inconveniences standing in the way of neighborhood fun. Victoria noticed those reactions and leaned into them. During one meeting, she projected a large map onto the clubhouse wall. The entrance road appeared highlighted in bright blue with the words primary community access printed across it. My property line had disappeared entirely beneath the graphic. I raised my hand and asked a simple question. Is that an engineering survey or a marketing illustration? Her smile tightened for the first time. It is simply easier for residents to understand. It is also inaccurate, I replied. She changed the subject within seconds, but the message had already spread through the room. Facts were becoming optional whenever they interfered with her version of the neighborhood. As I drove home that evening, gravel crunched beneath my tires, and the setting sun reflected off the calm water surrounding the bridge. I slowed near the eastern support where the maintenance truck had caused the damage earlier that week. The steel still carried faint scrape marks beneath the fresh dust. My inspection tags fluttered gently in the breeze exactly where I had left them. Victoria probably believed the rejected invoice had ended the conversation. She had no idea that every assumption she encouraged over the past several years had quietly built the foundation for the mistake that was about to cost the association far more than $28,500. The following Friday evening, the clubhouse parking lot filled long before the board meeting officially started. Luxury sport utility vehicles lined the curb, golf carts buzzed between parking spaces, and conversations drifted through the warm summer air with the familiar confidence of people who believed their biggest concern was choosing the menu for the upcoming Lake Festival. Inside, the room smelled of brewed coffee and fresh printer ink as stacks of meeting packets waited neatly on every table. Victoria stood at the front wearing another perfectly tailored blazer, greeting homeowners with effortless charm as though the rejected repair invoice had already faded into history. I arrived carrying nothing more than a slim leather folder. There was no dramatic entrance, no raised voice, just paperwork. When the financial agenda reached new business, I calmly asked to address the board regarding the damaged bridge. Victoria barely glanced in my direction before folding her hands together. The association has already reviewed that matter, she said smoothly. Our legal counsel determined there is no evidence that the neighborhood is responsible. Several homeowners nodded before they had even heard the rest of the discussion. I opened my folder and placed several glossy photographs on the front table. They showed fresh tire impressions across the bridge, scrape marks on the steel guardrail, and the clearly visible identification number painted on the maintenance truck involved in the incident. I followed them with printed inspection reports, engineering calculations, and repair estimates prepared under my professional license. The room grew quieter as the pages circulated from one board member to another. Even people sitting in the back leaned forward. Victoria looked at the photographs for only a moment before sliding them aside. Accidents happen, she said with a small shrug. Infrastructure requires maintenance over time. I answered calmly. Maintenance is replacing worn materials. Driving overloaded equipment across a restricted bridge and damaging a structural member is something entirely different. One of the older homeowners, Mr. Harrison, adjusted his reading glasses and frowned at the inspection report. Did our contractor really cross a posted weight limit? Before anyone else could answer, Victoria spoke again. Those signs are advisory. I looked directly at her. No, they are engineering restrictions. There is a difference. A faint murmur spread across the room. For the first time all evening, several residents stopped looking at Victoria and started looking at the photographs instead. She noticed immediately. Her smile never disappeared, but it became noticeably tighter. Regardless, she continued, the association will not authorize payment based on a private estimate. I slid one final document onto the table. It was the contractor's own vehicle log obtained through a routine public records request. The date, time, truck number, and maintenance assignment matched my security footage down to the minute. Silence settled over the clubhouse. The only sound came from the ceiling air conditioner humming above us. One board member quietly cleared his throat and asked whether insurance should at least review the claim. Victoria answered before anyone else had. The chance. The matter is closed. She struck the small wooden gavel once and immediately moved to the next agenda item, as though $28,500 in documented damage had simply vanished with a tap of polished wood. Around me, chairs shifted uncomfortably. A few homeowners avoided eye contact. Others looked confused rather than convinced. I gathered my documents one page at a time without rushing. As I placed the last photograph back inside my folder, I noticed something sitting beside Victoria's notebook. It was the neighborhood access map she loved presenting at meetings, the one that colored my private entrance bright blue as if ownership could be redesigned with graphic software. She still believed control came from repeating the same story often enough. She had no idea that I had already stopped arguing about the story. My attention had shifted entirely to the documents that actually mattered. By Monday morning, the excitement from the board meeting had settled into something much quieter. Rumors. They moved across Lake Haven shores faster than fishing boats at sunrise. Some homeowners insisted I was exaggerating the damage to force the association into paying for routine maintenance. Others believed Victoria had simply handled the situation poorly. A few stopped to ask me questions whenever I inspected the bridge, but most preferred to wave politely and continue driving across it as though nothing had changed. I could hardly blame them. People naturally assume the road they used yesterday will still be there tomorrow. My attorney, Richard Lawson, called just after 9 while I was reviewing sensor readings from the Eastern Support. His voice carried the calm tone of someone who had spent 30 years settling property disputes. I received their response, he said. Their legal counsel denied liability again. I asked whether they had addressed the engineering report. Not directly, he replied. They argue the association has acquired implied maintenance rights because residents have continuously used the entrance for years. I looked out toward the bridge where another family crossed in a silver pickup truck, completely unaware of the conversation taking place over their heads. Usage does not transfer ownership, I answered. Richard laughed softly. I know that. You know that. Unfortunately, they are hoping someone else forgets it. The next few days became an exercise in patience. Letters arrived from the HOA attorney filled with polished legal language, but very few actual facts. Every paragraph seemed designed to delay rather than resolve the issue. They requested additional inspections that had already been completed. They questioned photographs that clearly showed their maintenance vehicle. They suggested ordinary where despite receiving engineering calculations proving otherwise. Every afternoon, I organized another binder, labeled another photograph, and updated another file. I never raised my voice. Documentation always lasts longer than frustration. Still, I would be lying if I said the situation did not wear on me. Every evening, I walked the length of the bridge listening to the quiet hum beneath the steel as tires rolled overhead. The lake reflected orange sunsets that should have felt peaceful, yet all I could think about was my father's promise that neighbors respected each other's property because trust mattered more than fences. That promise seemed increasingly outdated. One afternoon, I stopped by Miller's Hardware for replacement inspection tags. Old Frank Miller, who had known my family since childhood, leaned across the counter after scanning the local newspaper. Sounds like that HOA thinks they own half the county now. I smiled. Only the half they do not actually own. He chuckled before becoming serious. Your grandfather kept every document he ever signed. If anybody left a paper trail, it was Walter Caldwell. His words stayed with me during the drive home. The smell of fresh-cut grass drifted through the open truck windows, while sunlight flickered between tall pines lining the lake road. I had already reviewed deeds, surveys, and inspection reports dozens of times. Still, something about Frank's comment would not leave my mind. My grandfather never trusted memory when paper could preserve the truth. That evening I unlocked the old cedar filing cabinet in my father's workshop, the same cabinet that had not been fully opened since the estate was settled years earlier. Inside were neatly labeled folders, faded engineering sketches, handwritten notes, and decades of county records organized with almost obsessive care. Dust floated through narrow beams of afternoon light as I lifted the first heavy binder onto the workbench. I had entered the workshop searching for reassurance. I had no idea I was about to find something that would change the entire dispute from a disagreement over repairs into a question of legal access itself. The old cedar cabinet smelled like dry pine, machine oil, and decades of careful habit. My grandfather believed every important piece of paper deserved a proper home, and my father had inherited the same discipline. Each binder carried a handwritten label instead of a printed tab. Property surveys, utility easements, bridge engineering, county correspondence. Nothing was thrown together. Everything had its place. I spent nearly 3 hours turning brittle pages while the afternoon sunlight slowly shifted across the workshop floor. Outside, cicadas buzzed in the oak trees, and every now and then I heard another vehicle crossing the bridge, the faint vibration traveling through the concrete foundation beneath my boots. I eventually reached a thick binder labeled Access Agreements, 1974 through present. Inside were signed permissions dating back almost 50 years. Every property owner who had ever purchased a lake house acknowledged the same basic arrangement. The bridge, entrance road, and security gate remained private property owned by the Caldwell family. Residents received a revocable license for access, not an ownership interest. The wording was nearly identical in every agreement because my grandfather hated ambiguity. Then a folded document slipped from the back cover and landed on the workbench. Unlike the others, it carried a bright red stamp from the county recorder's office. It was an amendment executed nearly 15 years earlier when the subdivision expanded from 12 homes to 32. I unfolded the pages carefully and read every line twice. Then I read them a third time. My pulse slowed instead of racing because that is what happens when certainty replaces suspicion. There was in plain English. Continued access depended upon compliance with several conditions, including the obligation to repair any damage caused by the association, its contractors, agents, or authorized vendors using the private entrance. Failure to satisfy that obligation after written notice constituted a material breach, allowing the property owner to suspend access until the breach had been cured. I leaned back in my chair and stared at the paper without saying a word. The clause had been sitting there all along. Nobody had hidden it. Nobody had rewritten it. Everyone had simply forgotten it existed. Or perhaps they had assumed no one would ever bother reading it again. I scanned the amendment and emailed it to Richard Lawson. Less than 20 minutes later, my phone rang. "Please tell me this came from the original county filing," he said before I could answer. "It did," I replied. "Stamped, recorded, and cross-referenced." I heard pages turning on his end of the line. "Ethan, this changes everything. They are not arguing with an invoice anymore. They are in breach of their own recorded access agreement." I asked the question already forming in my mind. "If they continue refusing payment?" Richard paused only briefly. "Then you have the contractual right to suspend access after proper notice. Not permanently, only until they comply. The agreement is remarkably clear." I thanked him and ended the call before walking outside. The evening air carried the familiar scent of lake water and cedar, while the bridge stretched quietly across the inlet exactly as it had every day of my life. Families continued driving toward their lake houses without noticing anything different. Children laughed from a nearby dock. Fishing boats drifted lazily across the water. Everything looked completely ordinary. Yet nothing was ordinary anymore. Victoria believed she had won because her board voted against paying $28,500. She had never imagined that refusing one repair bill had activated a clause powerful enough to place the only entrance to every lake house back under the exact conditions my grandfather had written decades earlier. For the first time since this dispute began, I was no longer wondering how I would respond. I knew precisely what the agreement required, and unlike the association, I intended to follow every single word. The next morning began before sunrise. Fog drifted lazily across Pine Hollow Lake, softening the outlines of docks and boathouses while the water reflected pale shades of blue and gray. I unlocked the maintenance shed beside the bridge and spread every relevant document across the workbench one final time. The recorded access agreement sat on top, followed by the engineering report, the repair invoice, certified mail receipts, photographs of the damaged support beam, and Richard Lawson's formal notice confirming that the association had materially breached its obligations under the agreement. I checked every page twice. My grandfather always believed preparation was a form of respect, especially when the law was involved. If I was going to exercise a contractual right that affected dozens of families, everything needed to be precise. By mid-morning, certified notices had already been delivered to the HOA office, each board member, and the association's attorney. The language remained professional from beginning to end. There were no threats, no dramatic accusations, and no emotional remarks. The notice simply explained that the documented breach had not been cured within the required period and that access privileges would be temporarily suspended until the contractual obligations had been satisfied. Richard reviewed every sentence before it left his office. Even the delivery times were carefully documented. Afterward, I drove into town and met a local locksmith who specialized in commercial access systems. We replaced the aging electronic cylinder at the security gate with a modern unit that logged every entry attempt automatically. Nothing about the installation damaged the existing gate. We were simply updating equipment located entirely on my property. Next came new reflective signage mounted beside the entrance. The lettering was impossible to misunderstand. Private property. Temporary suspension of licensed access pursuant to recorded agreement. Contact property owner or legal counsel for information. Every word matched the legal notice exactly. I also hired a licensed private security company for the following morning. Their instructions were straightforward. Remain polite. Do not argue. Do not physically interfere with anyone. Simply provide copies of the recorded agreement and direct all questions to legal counsel. Later that afternoon, I called the county sheriff's office through the non-emergency number. I explained that a contractual access dispute might generate confused phone calls from residents unfamiliar with the property records. The deputy appreciated the advance notice and requested digital copies of the recorded documents, which Richard had already forwarded earlier that day. Everything remained calm because everyone involved knew what to expect before it happened. As the sun settled lower across the lake, I walked the length of the bridge one more time. The repaired inspection markers fluttered gently in the evening breeze, and the damaged support beam remained wrapped with bright orange safety tape, waiting for restoration work to begin. I rested my hand against the cool steel and remembered my father's voice telling me that ownership carried responsibilities before it carried privileges. He had never used the bridge to intimidate anyone. Neither would I. This was never about revenge. It was about enforcing an agreement that every homeowner had accepted long before moving into Lake Haven shores. Across the water, I noticed lights coming on inside the lake houses as families prepared dinner, completely unaware that the following morning would begin differently than every other morning they had experienced since buying their homes. Victoria still believed the rejected invoice had ended the dispute. In reality, it had only started the countdown to the exact consequence her own association had agreed to years before she ever became president. The gate closed with a quiet mechanical click at exactly 6 o'clock the next morning. There was no dramatic announcement, no flashing lights, and no raised voices. Just the soft hum of a new electronic lock engaging for the first time. Mist floated above Pine Hollow Lake while the first rays of sunlight reflected off the calm water, making the entire shoreline look almost peaceful. At 6:15, the first homeowner arrived in a dark blue pickup truck, slowed in front of the closed gate, rolled down his window, and stared at the new sign. He read every line twice before stepping out and approaching one of the security officers. The officer handed him a neatly prepared packet containing the recorded agreement and Richard Lawson's contact information. The homeowner thanked him politely, returned to his truck, and made a phone call. Within 20 minutes, a line of vehicles stretched along the entrance road. Luxury sport utility vehicles, fishing boats on trailers, contractors scheduled to work on lake houses, landscaping crews, and delivery trucks all waited quietly while drivers walked toward the gate carrying confused expressions instead of anger. Most simply wanted to understand what had happened. Every person received the exact same explanation. Temporary suspension of licensed access due to an unresolved contractual breach. Please contact the association. Shortly after 7 o'clock, Victoria Hale arrived. Her white sport utility vehicle rolled to the front of the line before stopping abruptly beside the gate. She stepped out wearing sunglasses despite the cloudy morning and walked directly toward me with determined confidence. "Open the gate," she said. I handed her the same packet everyone else had received. She glanced at the first page before shaking her head. "The association does not recognize this action." I answered calmly. "The county recorded the agreement years ago. Recognition is not required." She insisted the residents had permanent rights because they had used the entrance for years. I pointed to the highlighted clause already marked inside her packet. The agreement explains exactly when access may be suspended. For several long seconds, she said nothing. Her eyes moved slowly across the page before returning to me. Around us, conversations became quieter as more homeowners realized she was reading an actual recorded document rather than arguing over opinions. At 7:45, two sheriff's deputies arrived exactly as expected. They greeted everyone professionally before asking to review the paperwork already provided in advance. One deputy compared the certified copies against the electronic county records on his tablet. After several minutes, he nodded toward his partner. They approached Victoria together. One deputy explained that the dispute appeared to involve a private property agreement rather than a criminal matter, and that the recorded access conditions remained enforceable unless modified by a court. Several homeowners standing nearby exchanged surprised looks. One older resident quietly asked Victoria whether the board had ever mentioned this agreement during meetings. She did not answer immediately. Another homeowner wondered aloud why the association had refused to submit the repair claim to its insurance company in the first place. Questions began replacing assumptions. By mid-morning, the atmosphere had completely changed. Nobody was criticizing the bridge anymore. Instead, residents were comparing copies of the agreement while discussing board decisions they had previously accepted without question. My phone rang just before noon. Richard Lawson spoke only one sentence before pausing. Their attorney would like to schedule an emergency settlement meeting this afternoon. I looked across the closed gate toward the lake houses sitting peacefully beyond the bridge. The lock had never been the real turning point. The truth was, once everyone finally read the same document, the story Victoria had repeated for years could no longer compete with the words already recorded in black and white. The settlement meeting lasted less than 2 hours. That surprised me more than anything else. After weeks of confident letters and carefully rehearsed denials, the association's attorney spent most of the meeting asking questions instead of making arguments. Richard Lawson placed the recorded agreement, the engineering reports, the maintenance vehicle logs, and the certified notices across the conference table in perfect order. Nobody interrupted. Because there was very little left to debate. The documents spoke for themselves. By late afternoon, the board voted to authorize full payment of the $28,500 repair invoice through the association's insurance carrier, reimburse my legal expenses related to enforcing the access agreement, and formally acknowledge the Caldwell family's ownership of the bridge, entrance road, and security gate in future community records. More importantly, they agreed to revise every welcome packet, neighborhood map, and public document so that no future homeowner would be misled about who actually owned the entrance. Victoria remained unusually quiet throughout the meeting. The confidence that had once filled every sentence was gone, replaced by long pauses and careful glances toward the association's attorney before she spoke. Nobody celebrated her leadership anymore. Several board members openly questioned why the repair claim had never been submitted to insurance in the first place. Others wanted to know why the recorded agreement had not been reviewed before rejecting my invoice. Those conversations belonged to the association, not to me. My responsibility ended when the agreement was honored. The following morning, the insurance company confirmed payment, and Richard called with the words I had been waiting to hear. The breach has officially been cured. I thanked him, hung up, and drove to the bridge just after sunrise. The lake looked exactly as it always had. Gentle waves tapped against wooden docks. A pair of herons stood motionless near the shoreline. The cool morning air carried the familiar scent of cedar and fresh water that had followed my family for generations. I walked to the security gate, unlocked the new electronic system, and listened as the mechanism released with a soft click. The sound was almost identical to the one it had made when it closed the previous morning. Funny how the same noise can mean two completely different things depending on the choices people make. The first residents arrived only a few minutes later. Several slowed to wave before crossing the bridge. One older couple rolled down their window just long enough to thank me for resolving the situation peacefully. Another homeowner apologized for assuming the association owned the entrance. I smiled and told him the truth was finally available to everyone now. That was enough. Before leaving, I installed one final bronze plaque beside the gate. It was simple, smaller than most people would expect, and impossible to misunderstand. It read, "Private access. Caldwell family property. Entry by recorded agreement." Nothing more. Nothing less. I stood there for a moment watching the morning traffic flow smoothly toward the lake houses. Hearing tires roll across the bridge my grandfather had imagined, my father had strengthened, and I had protected, I realized the real victory had never been about locking anyone out. It was about reminding everyone that respect for property, promises, and written agreements keeps communities stronger than pride ever will. My grandfather had been right all those years ago. People rarely notice the gate when it opens every day. They only notice it after they forget why it was built in the first place. And sometimes, the quietest lesson leaves the deepest impression. Justice never needed to shout across Pine Hollow Lake. It only needed the right documents, the patience to follow them, and the willingness to unlock the gate again once fairness finally found its way home.